Last spring, I got a panicked call from a widow whose multi-million dollar estate plan was about to fall apart. Not because of poor planning, but because of something most people don't spend enough time thinking about when they create their trust. By the end of this video, you'll know exactly what that something is and how to make sure it doesn't happen to your family. Hi, I'm Chuck Roulet. I'm an estate and elder law planning attorney licensed in both Florida and in Minnesota, and I've been helping families protect their wealth for almost 30 years. I've seen brilliant estate plans crumble because of often overlooked details, and I've helped families avoid disasters that could have cost them tens of thousands of dollars and destroyed family relationships. And in today's video, I want to share a story that might sound familiar and show you how to protect your family from this hidden estate planning trap. Now, before we begin, if you haven't already, make sure to click the like and subscribe buttons so you'll be notified when I post new videos like this one. If you have a question, post it in the comments below and I may answer it in an upcoming video. And if you stay until the end, I'll share some resources where you can discover more. So Sarah and her late husband had seemingly done everything right. They'd worked with an attorney and set up trusts for each of them along with a life insurance trust, all designed to take care of them and their kids while minimizing estate taxes on their estate. Sarah's late husband, he'd named his trusted executive assistant as trustee, someone who'd worked with him for 15 years. 3 years after his death, Sarah gets a call. The assistant is retiring. She can't handle the trustee responsibilities anymore. And the backup trustees? Well, one had died, another had developed dementia, and the third had retired to Europe and declined to serve. Suddenly, Sarah had two now irrevocable trusts worth millions, and no one legally authorized to manage them, and the family was panicked. Now, here's what most people don't realize. Your trust will likely outlive your trustees. So if you're 60 and you name your 55-year-old brother as trustee, what happens in 20 years when he's 75 and dealing with health issues? I've seen this scenario play out multiple times. The Johnson family, for example, spent $47,000 in legal fees and 18 months in court because their trustee had a stroke and couldn't serve, all because they didn't plan better for trustee succession. The good news? There are smart solutions that can help to prevent these problems. First, have multiple backup plans. Don't just name one successor trustee. You can name as many as you want, but ideally, you'll have at least one backup in case your primary trustee is unable or unwilling to serve. Second, include provisions for a trust protector. Not only can you authorize your trust protector to remove and replace trustees, you can also give them the authority to modify trust terms if the laws change and make other necessary adjustments. Think of them as your estate plan's guardian angel. I've recorded a separate video on trust protectors that I'll provide a link for in the description below if you'd like to discover more. Third, in addition to including a trust protector for your trust, a well-drafted trust can also include provisions for naming a successor trustee by the beneficiaries or others in the event all of your named trustees are unwilling or unable to act. Fourth, you can use tools like nonjudicial settlement agreements. Now, in Sarah's case, we used this to appoint a new trustee in just a few weeks instead of 6 months, costing a few $1,000s instead of potentially tens of thousands in court costs and attorney's fees. Fifth, review your plan every 3 to 5 years. Your trustees age, circumstances change, laws evolve. Your estate plan needs to evolve as well. For successful families with larger estates, we often use even more sophisticated tools. Decanting lets us update old trusts with new terms. Directed trusts can split responsibilities. For example, one person handles paperwork, another manages investments, a third makes distribution decisions. The cost to update your estate plan with proper trustee succession? Well, it's usually a few $1,000s. The cost when trustee succession fails? Potentially many multiples of that in legal fees plus months of family stress. So here are some potential warning signs that your trust may need attention. First, your trustees are within 10 years of your age. Second, you haven't reviewed your plan in over 5 years. Third, your backup trustees live far away. Fourth, you've only named one or two successors. Or finally, if you've never actually discussed trustee duties with your named trustees. If any of these apply to you, well, then it's time for a review. Don't let your family become another cautionary tale. If you would like to discover more or to schedule a consultation to discuss your own planning, visit our website at rouletlaw.com. I'm also hosting an exclusive online masterclass where I'll be revealing strategies I use with my private clients to help them avoid probate, save on taxes, protect the money they leave for their kids in the event they get divorced, and much more. And you can join us by clicking the link in the description below to sign up. If this video helped you understand something important about estate planning, please give it a thumbs up and subscribe for more insights that could protect your family's wealth. And remember, the best estate plans anticipate problems before they happen. I hope you found this video helpful, and I look forward to seeing you in either an upcoming video or the masterclass. Be well.